It's clearly a very good evening, but a very good evening, ladies and gentlemen. It's a pleasure on behalf of the Express Group to welcome all of you to the third Ramnath Goenka lecture, and a warm welcome on behalf of our title sponsor, OP Jindal Global University, and our associate partner, CNBC TV18. Now, it's very difficult to say all this to such a distinguished gathering, but I think I'll have to. So if you could kindly ensure that no one else finds out what your ringtone is, if you could kindly put your phones on silent, we'd be very grateful for the duration of the program. The Ramnath Goenka lecture series was started to mark 25 years of the passing of our founder, Ramnath Goenka. This was started 3 years ago, and the lecture is really a tribute to his complete and absolute commitment to speaking truth to power in all circumstances, his courage, and his commitment to even communications and ensuring that there is robust communication at all times, irrespective of what the atmosphere is around us. But before we go further into that, may we have a small audiovisual on Ramnath Goenka ji.
On Akshay Tritiya of 1904, a boy was born in the Darbhanga village of Bihar, who would go on to change the face of politics and press in India. Ramnath Goenka moved to Calcutta as a teenager and was put under the tutelage of his maternal uncle, Mahadevlal Ji Dalmia. At 22, he moved to Madras to start trading in jute, but was known to be one of the many businessmen supporting the freedom movement in Chennai. Ramnath Ji grew inspired and moved by Gandhi's messages of non-violence. In 1932, in an answer to Gandhi's call for a pro-freedom English newspaper, the Indian Express was launched, which courageously gave voice to the millions of freedom fighters across the country. During the Quit India movement, when Gandhiji was arrested and the press given gagging orders, Ramnath Ji decided to suspend the publication of the Express, demanding Gandhi's release. He said,
"If we went on publishing, the Indian Express may be called a paper, but cannot be called a newspaper. We have therefore decided that this would be our last issue."
Recognized as a courageous freedom fighter, Ramnath Ji was one of the privileged members of the Constituent Assembly and tasked with drafting India's constitution. After independence, the Indian Express took to the role of nation building. Ramnath Ji engaged some of the world's most recognized editors to bring global standards in journalism to India. Here he's seen with Devdas Gandhi of Hindustan Times in London leading a delegation to form the Swadeshi News Agency, Press Trust of India. In the early 70s, when the country's most popular Prime Minister, Indira Gandhi, split the Congress in Congress I and Congress O, he told her,
"You're making a big mistake, Indu."
She asked him.
Are you a friend or a foe?
He replied quickly.
"The choice is yours."
In 1975, Mrs. Gandhi declared emergency.
हमें अपनी आजादी कायम रखनी है.
Jayaprakash Narayan led the first revolution to fight the emergency with Ramnath Ji's full support. Through the emergency, the government's approach to the press was to tame or take over. Possibly, the most drastic step taken by the government was to send this notice to the Directorate of Advertising and Publicity to stop advertising in all Express Group publications. Unlike today, in the late 70s, the government was the largest advertiser in the country. This letter shows several fraudulent cases of income tax violations issued by the CBI against the Express. And here, the emotional letter Ramnath Ji wrote to KK Birla after the government forced him to resign from the board of his own company and appointed KK Birla as the chairman of the board. He wrote,
"Parting with the Express is like parting with my son. You said that if I don't fall in line with this proposal, all the members of my family would be held in detention under MISA."
During the emergency, all edits were vetted and cleared by the government. One day, when his edit was not cleared according to his liking, Ramnath Ji published a blank editorial. This blank edit page became a symbol of protest against press censorship around the world. But Ramnath Goenka could never be removed from the Express. He got back in control as soon as the emergency was removed. Here, at another attempt to control the free press, he took to the streets with placards. To encourage excellence in journalism, he instituted an award. And here is Swami Chinmayanand giving away the award to R.K. Lakshman. What will inspire journalists in India and around the world, however, will be his role as publisher of the country's most independent news organization, the Indian Express. And today, 25 years later, The Express continues to inspire independent journalism.
So this is the third Ramnath Goenka lecture. The first two, just a short recap. The first was by then Governor of the Reserve Bank of India, Dr. Raghuram Rajan, and he spoke about India in the global economy, the importance of stability in order to get any kind of reforms off the ground and make them meaningful. The second lecture was delivered by the then President of India, Mr. Pranab Mukherjee, and he spoke about the role of the media and what actually starts going wrong when that role is not performed by sections of the media. And for the third lecture, we are really honored that Justice Ranjan Gogoi, Judge, Supreme Court of India, has agreed to unveil his vision of justice. And all our lectures so far, and I have no doubt this one too, have of course been very relevant to their times, but they've helped shape the debate that took place in the country around the subjects that they chose to tackle. May I kindly request Mr. Ananth Goenka, the Executive Director of the Express Group, to please escort Justice Ranjan Gogoi on stage. And may I please request Mr. Rajkamal Jha, Chief Editor of the Indian Express, to please welcome Justice Gogoi. Raj.
Thank you, Seema. On behalf of the Indian Express Group and its chairman, Mr. Vivek Goenka, I welcome you to this very special evening. I'm sorry I shall repeat Seema's request about the phones. We have heard a lot in the last couple of months about a poem where the mind is without fear and the head is held high. These days, the head cannot be held high if we don't have the phone in the hand. So it's good to keep the phone out of the hand, only then can you hold the head high. Because as much as speech, we also cherish silence. We envisaged this lecture as opening a very invaluable space in our national conversation. A space which is free of noise, where we gather to listen with respect. We have worked very hard to ensure that for the next 1 hour or so, the only distraction, if any, will come from the sound of a pin dropping as we listen to Justice Ranjan Gogoi, our chief guest and our speaker. There could not be a more fitting tribute to Ramnath Goenka than this. For Ramnathji, the Supreme Court was not just a vital port of call during stormy weather. It was also a lighthouse that marked the way in the dark. It showed where the rocks were lurking. That helped him ensure that to this day, fear or favor can never enter the newsroom of the Indian Express. Be it the Indian Express versus Union of India case in 1984, which linked fiscal freedom to free speech. The more recent Shreya Singhal case unshackling speech online. In ruling after ruling, it is the Supreme Court which has expanded our freedoms of speech and expression. That is why, whenever there's a knock on our door, it's the court's doors we knock on. In fact, in a way, the courtroom and the newsroom are kindred spaces. Not just because they are, to quote Justice Lodha, who said this a couple of months ago, the heart and the soul, respectively, of democracy. But because the search for justice, what the court does, and the search for facts, what we aspire to do in the newsroom, at the heart of both is a solid process that is adversarial. Underlying both is a sharp acknowledgement of the fact that there are at least two sides, if not more, to a story or a case. That a conflict is natural and even necessary. That each side should have a voice, and each has to be heard without fear or favor. No wonder courage and compassion, which are the calling cards of good jurisprudence, are also the calling cards of good journalism. One thick red line in the newsroom, which we tell all our reporters, is never impute a motive to a judgment or a judge. I'm going to push that line and I'll take some liberty here. Justice Gogoi's work and his words reinforce the feeling, reinforce the perception that fundamental to the search for justice is without fear or favor. Be it from the High Court in Guwahati to the Punjab and Haryana High Court, to the Supreme Court, or to a lawn on a winter morning in January, Justice Gogoi has always pushed to bridge the gap between what he calls constitutional idealism and constitutional realism. There are several examples, and I'm sure many in this room know that, but I shall cite one that is very illustrative of this. His ruling last year in the Ramnath Sao versus Govardhan Sao case, which expanded women's rights under the Hindu inheritance law. He wrote, and I quote the operative part, "Even assuming that two interpretations are reasonably possible, we must prefer that interpretation which will further the intention of the legislature and remedy the injustice from which women have suffered over the years, rather than the one that turns the clock back on social reform." It is this gap between constitutional idealism and constitutional realism that defines his work, between what is and what ought to be, between what justice means for us in this room and for those who can never make it to this room. For Justice Gogoi, the court's role is very straight and explicit. That's an incredibly powerful moral compass. If, to borrow the words of Ralph Waldo Emerson, an institution is the lengthened shadow of one man or a woman, Justice Ranjan Gogoi, as the second most senior judge today, lends the Supreme Court both shadow and guiding light. We are very privileged to have him here. So please join me in welcoming Justice Ranjan Gogoi to deliver the third Ramnath Goenka Memorial Lecture.
A very good evening to each member of this very august audience. Thank you for coming, and that too, perhaps straight from work, to share a few moments of thoughts with me. But let me begin by thanking the Express Group for giving me this rare honor to deliver this lecture in the memory of a great person who was an institution by himself, Ramnath Goenka ji. Tucked away in a remote corner of the country in Northeast, I regret not being able to meet Ramnath ji. But fortunately, I have not been untouched by his proud legacy. A legacy that gleams through what he had founded as an answer to Gandhiji's call to start a Swadeshi paper. Living in the realm of the Raj, it needed an iron will and an iron man, and we found it in a young Ramnathji. His legacy also gleams through the rich jurisprudence on the freedom of the press that he was instrumental in molding, and which, by virtue of my office, I work every day. It needed a committed and a cause-driven litigant, a rarity, which it is nowadays. And we found it yet again in Ramnathji. During the dark days of the emergency, he stood as an unwavering gatekeeper of those fundamental liberties that we hold so dear today. And that is his legacy too. Today, after all these years, some remember him as the warrior of the Fourth Estate. Some remember him as a dogged, unyielding adversary. Some remember him as an iconoclast. Some as a magnificent rebel. He was at times unapologetic, at times uninhibited, and at times even contradictory. But forever he was fierce, forever feisty, and forever fearless. His entire life trajectory, from Darbhanga to Calcutta to Madras to Bombay, from the Constituent Assembly to the newsroom to the courtroom, is a test case of its own kind that we perhaps need to use more often in our lives and in our institutions. Not too long back, I had read an interesting news article talking about the surprising surge, which is not so surprising, in the sale of George Orwell's 1984 in the United States. That piqued my interest in revisiting the classic. And for some reason, I want to recollect a thought from it today, which I would like to share with you. Permit me to quote: "Freedom is the freedom to say that 2 plus 2 makes 4. If that is granted, all else follows." If I had put it very simply, for me, this is what Ramnathji stood for. The freedom to say that 2 plus 2 makes 4. And that is how I remember him. Someone who could call a spade. Someone who could speak truth to power. Even if it came at a cost. To be ready to break, but not to bend, could be called obstinacy by some, and determination by others. It is a matter of perspective. Is it? I do not know. I cannot say for others, but as far as I am concerned, I only feel that we need to ask ourselves some questions. Where is the Goenka in us? His ideals, his values, is that extraordinary phenomena losing its relevance today after all these years. Why I have chosen the topic for this discourse merits a context too. And this is the context. These are some very sore questions, but too significant to get lost in the everydayness. And when it is so, what other better tribute can there be to a visionary who embodied in so many ways the spirit of a constitution than to spend a thought? To spend a thought over how far we have come to achieve the vision that he had seen as someone who had helped to free the country in one era and help it to become a meaningful democracy in another. I'll use a few minutes to put across my proposition as to what I intend to say when I talk about the vision of justice. I'll borrow from the chief editor, Rajkamal Jha himself, because it offers a very fine perspective, very powerfully, very thoughtfully, and very rightly. Jha had said of Ramnath ji, in one of his letters to me, we had exchanged some correspondence relating to the subject. And he said, fierce independence, an enduring sense of inquiry without fear or favor were the two values that Ramnath ji believed formed the bedrock of justice. It is absolutely incontestable that they do. And for convenience, let me call them the bedrock principles. But if I were to look at it anatomically, while these do indeed form the bedrock of justice, what is the form, what is the body of the ideal called justice, which rests on this bedrock? The bedrock principles have been the talk of the town lately, considering how the entire think tank is so keenly focused on it. I am not suggesting that it ought not to be. It ought to be done, and it is being done. I cannot recall the last time the judicial wing of the state made so much news. On a lighter note, the American founding father Hamilton, who had suggested that the judiciary was the least dangerous branch of the three branches, and I'll refer to him again during the course of my address. But were he to be here today, I wonder if he would have felt the same way. More so, in the light of the Indian Express top 100 most powerful Indians, which included several names from the judiciary. But the fact of the matter is that if we have to take stock of how we have fared, and about 7 decades later, since we have ventured into becoming a constitutional order, this appears to be an opportune time to do so. We might as well do it comprehensively. And by comprehensively, what I mean is that we must evaluate both the bedrock principles and the form principles, because the vision of justice, the way I understand, is a compound of both. Clearly, they are not unconnected. And over the course of the next about 20-25 minutes, I'll attempt to touch upon both. I'll begin with the form principles, and bear with me in order to drive home my point. I may have to get somewhat academic. You'll agree that in the backdrop of a bleeding mega partition, deeply entrenched inequities, perpetuating injustices, our Constitution ushered us into believing in a grand promise of transformation on a scale that was beyond reformatory. It was, in all its full glory, a revolution in all aspects of life, social, political, and economic. In a way, it said, let bygones be, and a new society that we would be egalitarian, while preserving our pluralistic character. We would be democratic and united too. The state would be religion neutral, the citizens equal and together. Coming to think of it, it was just as pretentious as it was unpretentious an idea. But be that as it may, public institutions, one of them being the judiciary, were inherited, they were tweaked where the need was felt to give life to this prodigious architecture of justice. And here I would like to clarify that by justice, I am not implying only the juridical connotation of the word, which is the administration of justice by the courts of law, although it is just as imperative. But justice is something that is an overarching principle, an underlying fundamental, the spirit, an order to say, which is why I say prodigious, because it was a confluence of many philosophies. Firstly, the Aristotelian, for instance, which suggests that the very essence of the state is justice, which according to the philosopher was a social virtue, good of others, equality, and fairness. When we peruse the preamble to the Constitution, our vision document, is it not that this ideology is enshrined in the words equality of status and opportunity? Or the utilitarian philosophy of John Stuart Mill, whose view was that justice was the greatest good to the greatest numbers. In the preamble, is this not enshrined in the principles of socialism and equality yet again? Or the relatively more modern one, the Rawlsian perspective, which is that justice as fairness is the most egalitarian and also the most plausible concept of liberalism. In the preamble, is this not reflected in the words liberty of thought, expression, and belief? So the preamble, if we deconstruct it precept-wise, is the very embodiment of these ideas. Justice is not something that is a standalone precept, but an amalgam of other ideals like socialism, democracy, liberty, equality, fraternity, to name a few. They are not isolated silos because their undying endeavor is to establish one discipline of overall justice of an inclusive society. And this is exactly what I meant by the form principles of justice as an ideal. As a composite unit called justice, this had been intended to be achieved by the legislature, the executive, and the judiciary. Now, it will make for an incredibly interesting, and if I may add, overwhelmingly contentious tale to tell how the executive and the legislature have performed on this front. But the scope of my discourse will be limited to the judiciary's endeavors in this regard. A few months back, I had the occasion to deliver the Justice P.D. Desai Memorial Lecture at Ahmedabad. And there I had proposed that attaining constitutional idealism, which Mr. Jha had mentioned, was not like chasing a rainbow. And the Supreme Court, through its pronouncements, had been reflecting it. It would not be a display of any pessimism of the intellect. If today I were to say that while indeed attaining constitutional idealism is not like chasing a rainbow, but it is so only in the courtrooms. Perhaps because the fields are where rainbows are. The point being that the way the nation is built and the way this grand vision of justice is attained in the confines of courts through judicial pronouncements and the way they are built on the ground are two very disparate realities. Agreed. The aspirational aspect of the Constitution and the operational aspect of the Constitution will always be two different notions. The aspirational aspect is high idealism of a kind that is almost moralistic and preachy. The operational aspect has to do with the very strange realities on the ground, almost defeating. But then, even if we may be slow to move to bridge the gap between the two, which itself is not an acceptable compromise, but we must at least not become retrograde. Take, for example, the Supreme Court's 2015 ruling in Shreya Singhal. It is a celebrated judgment, where the Supreme Court held the public's right to know was directly affected by Section 66A of the Information Technology Act. Interestingly, while doing so, the court was certainly inspired by, amongst other rulings, Ramesh Thapa, Brij Bhushan, Bennett Coleman. If you would recall, these were perhaps some of the earliest pronouncements protecting an independent Indian's speech and expression, and were delivered in the light of the rights of the press, which verdict themselves had endorsed that a democracy was a marketplace of ideas where the people had a right to know, that prior restraints were anathematic to a democracy, and that the foundation of speech and the press is the ark of the covenant of democracy. Shreya Singhal took this legacy ahead as it improved upon the jurisprudence on the independence of the press to attain and promote the constitutional precept of plurality of thought, diversity of opinion, and the ethos of democracy in the technical age and in the context of online speech. The vision of justice was indeed attained in the courtroom, not once, but multiple times. I ask myself, has it translated into reality? Has the success of these strong verdicts reached the ground? I will let the facts speak for themselves. On the ground, it appears to be a descent into chaos, and it is worrisome on all counts. When you sue the messenger, or you shoot the messenger, or when the messenger himself declined to deliver the message because of the fear psychosis. On 19th of June of this year, the Indian Express had published a very insightful article. This was selected from The Economist, titled as How Democracy Dies. It said at one place, independent judges and noisy journalists are democracy's first line of defense. reports of the death of democracy are greatly exaggerated. I'm quoting from Indian Express. But the least bad system of government ever devised is in trouble. It needs defenders. I agree. But I have a suggestion, a slight modification in today's context. Not only independent judges and noisy journalists, but even independent journalists and sometimes noisy judges. While Shreya Singhal was significant in its own right, Nalsa versus Union of India, the transgender case, breathed new life in the equality principle. The court understood that our founding fathers' vision about fundamental right against sex discrimination was to prevent differential treatment as a result of one's not conforming to generalizations. The judgment made a momentous foray into the fountainhead of dynamism. I'll come back to it, but before I do that, I must touch upon a very fascinating judgment of 1986 vintage. You all know about it. Bijo Emmanuel versus State of Kerala. This was a case where 3 Jehovah's Witnesses had refused to sing the national anthem when it was being sung in their school. They did stand up though. Nevertheless, they were expelled from the school. When the case found its way to the Supreme Court, while holding that the expulsion would be in violation of their fundamental right to freedom of conscience, the court observed that, I quote, "The real test of a true democracy is the ability of even an insignificant minority to find its identity under the country's constitution." The court also felt the need to add a thought, and I feel compelled to quote it. It is the penultimate line of the verdict, and it says, I quote, "Our tradition, thank you, teaches tolerance. Our philosophy preaches tolerance. Our constitution practices tolerance. Let us not dilute it." Recently, in Adi Saiva versus State of Tamil Nadu, this was sometime in 2016-17, the Supreme Court held that even in matters of religious beliefs, constitutional legitimacy cannot be forgotten. And following the great Justice B.K. Mukherjee in Shirur Mat of 1954 vintage, the court went on to hold that it is not the state or the religious Indian, but it is the constitutional court which decides on what constitutes essential practices of any particular religion. Some of you could be wondering how these judgments are even related. They are not, but they are at the same time. This similarity is that the first one originates in a very intimate, private sphere of life, and the other two originate in what everybody seems to want to have a say in, the matter of faith. But it is the similarity that should be the takeaway. The judgments beyond their bare letter say that societal morality is fickle, and not societal morality, but it is constitutional morality that ought to dictate terms. As an Israeli judge, Aaron Barak, points out, it is not the transient spirits of time, but the fundamental values that should be the guiding voice. In his last address to the Constituent Assembly, Dr. Ambedkar had said that we must not only be a political democracy, but a social democracy, as the former cannot last unless lies at the base of it the latter. And social democracy he defined as a way of life which recognizes liberty, equality, fraternity as one principle. I wouldn't want to wade into knowing if we are a successful political democracy, but I do honestly believe that we are a social democracy in all respects. And the disparity is there because the two Indias, both just as perceptible, are in conflict. There is an India that believes that it is the new order, and there is an India that lives behind a ridiculously drawn poverty line, on daily wages, in night shelters, with no access to education or healthcare, let alone access to courts. The ambivalence is intriguing, and this is exactly what I call as getting lost in transition. One India, in the above-mentioned perspective, is a vision, and to know how far we have succeeded in attaining this vision of justice is really a matter of perception. But nevertheless, there is a graphic disparity right there, and removing this disparity will be the mission for the Indian judiciary in times to come. And I may add that for that to happen, it is going to require a constitutional moment of its own kind in the life of this institution, which I believe has been long overdue. The constitutional history with reference to this institution as a whole, and especially the Supreme Court, would show that its own roles have constantly evolved in the light of the socio-political context. In the 1970s and 80s, it was a decade where the Supreme Court expounded the basic structure doctrine. In the 80s, it constantly expanded the scope of Article 21. And by the 1990s, it became somewhat of a good governance court by innovatively interpreting constitutional provisions to address the inadequacies consequent upon executive and legislative inactivity. In the first 50 years since our independence, the Supreme Court has created a very sound jurisprudence, which we continue to reap from. It is the inertia, really, that has kept us going till now. But the way things stand today, court processes are a trial, even before the trial has begun. While I cannot say if it is a collective failure on our part, but for a nation governed by the rule of law, is it not a matter of concern that to this extent, at least, we are defying the idea of inclusiveness? Not a reform, but a revolution is what it needs to be able to meet the challenges on the ground and keep this institution serviceable for a common man and keep it relevant for the nation. For the effectiveness of the judgments to show, the justice dispensation system has to be made more result-oriented, namely to say, more focused on enforcement. I understand what Mr. Arun Suri, he is not present today, had suggested when he wonders if the judiciary is not being an accessory to the resulting deterioration, which in its hopefulness and optimism doesn't go after its mandate till its implementation. We give it up halfway. I find it difficult to agree with Mr. Suri and his proposition wholeheartedly. But I will certainly say that the judiciary must be more proactive and more on the front foot. This is what I would call as redefining its role as an institution in the matter of enforcement and the efficacy of the spirit of its diktats, of course, subject to constitutional morality. Here, separation of powers. I'll even go ahead to say that the institution at all levels needs to be more dynamic in a matter of interpretation of laws. And this is what I mean to say by a constitutional moment of its own kind. However, it is going to be a tall order, both at the micro level and the macro level, because both come with their unique sets of challenges. By micro level, what I mean is the administration of justice on a day-to-day basis. Here, the so-called inefficiency and slow processes in the judiciary have been historical challenges. I'll put it very simply. The judiciary today is not a poor workman who blames his tools. It is a workman with no tools. I am not going to keep you busy with the figures that we keep consuming every day on pendency, areas, judges' strength, etc. But in the light of what a French author had once said, I quote, "Everything has been said already, but as no one listens, we must begin again." I will only ask and request those at the helm to finally listen so that we must not have to begin again. In addition to that, I also feel that there is a pressing need to explore the endless limits of legal services mechanism. Legal awareness and legal empowerment of the marginalized in this vastly unequal society of ours have to be made an observable reality. Let me give you one instance which is glaring insofar as personal liberty is concerned. 67% of the prison population in India are under trials, most belonging to the absolutely underprivileged classes. 47 of the 67% are between the age group of 80 to 30. Compare this with the UK, where the percentage is 7. And the US, which is acknowledged to have a high rate of incarceration, the percentage there is 22. The period of about 1 year that a majority of the under trials have been in custody would hardly redeem the situation. Will it be wrong to suggest that a fair share of a demographic dividend is being unjustifiably lodged in jails and mostly for petty or less serious offenses? I call the young population of India 18 to 30, which constitutes more than 50% of the population, as our demographic dividend. They are an asset. At the macro level, the judiciary as an institution is being seen as a course corrector, a leveler, a democratizer of sorts. And since it is too well known that our country is on the cusp of an evolution, naturally, it will have implications for the judiciary as an institution also. I would like you to recall that I had mentioned about Hamilton in the beginning of the discourse. While contemplating the US Constitution, he had said, the judiciary is the weakest of the three branches because it neither has the force of the executive nor the will of the legislature, but only judgments. This, and which I agree, he said, was the simple view of the matter. Correct. But there is a complex view also. The complex view is this. And this is something that Hamilton was envisaged and foresaw 2 centuries ago. He had said that while civil liberties will have nothing to fear from the judiciary alone, they will have everything to fear from the union of the judiciary with either of the 2 branches. I would like to believe this is why Ramnath ji had also said that fierce independence is indeed the bedrock of justice. But I'd like to add that independence must always be responsible with due regard to established constitutional values. This institution, the judiciary, is the last bastion of hope and the one that the citizenry believes firmly will give justice to them, come what may. And it has. The judiciary, with whatever little it has at its hand, has been a proud guardian of the great constitutional vision. It fills me with immense pride to see that as an institution, the judiciary has been endowed with the greatest societal trust. This fact gives it credibility, and this very credibility gives it legitimacy. It is a very enviable spot for an institution. I'll only say that if it wishes to preserve its moral and institutional leverage, the judiciary must remain uncontaminated and independent and fierce and at all times. A chain is only as strong as its weakest link. So is an institution. And if introspection is where we have to begin, we might as well begin there. Perhaps we can hope and endeavor that in the future, it is not our finality, but our infallibility that should define us. It is my imagination of an ideal world, and I am aware of what Carl Jung has said of it. He said, I quote, "Every form of addiction is bad, no matter whether narcotic be alcohol, morphine, or idealism." I don't know how true his views are on alcohol and morphine, but as far as idealism is concerned, I would say it should be pursued like an axiom. Ladies and gentlemen, thank you for your patience. Jai Hind.
So let us begin again. I think between shadow and light, noisiness, independence, morphine, idealism, I think it's been just a wonderful, long journey, sir. Thank you so much for a very thoughtful, expansive, and a wonderful unveiling of your vision of justice. May I request Mr. Ramnath Goenka to please present a small memento on behalf of the Express Group to Justice Gogoi. Misa is an illustration, it's a portrait of you by our chief illustrator, Shyam Kumar Prasad. So it's drawn specially for you. May I request you to just stay on the stage for a little bit longer? And may I request the founding Vice Chancellor of the O.P. Jindal Global University, Professor C. Rajkumar, to please come up and deliver the vote of thanks. Thank you.
Good evening to all of you. On behalf of O.P. Jindal Global University and Jindal Global Law School, I would like to express my heartfelt thanks and profound appreciation to Honorable Mr. Justice Ranjan Gogoi, Judge Supreme Court of India, for delivering an inspiring and deeply engaging lecture. Justice Gogoi's lecture on visions of justice, challenging the role of law and institutions at a critical time when the most fundamental notions of justice are under strain both in India and around the world. Rule of law is about people and institutions taking complete responsibility and commitment to adhere to the Constitution and the laws made under it. Justice Gogoi has recognized that there is a symbiotic relationship between the principles of the rule of law and the aspirations of society to achieve justice. In fact, the visions of justice that Justice Gogoi articulated cannot be achieved unless and until all holders of power recognize that they need to follow the law. It is equally important that when the law is violated, accountability is ensured as opposed to impunity. Only consistent adherence to the rule of law can help us build a society based on the rule of law. And for that purpose, we need both independent journalists and noisy judges. The victims of justice that Justice Gogoi so compellingly spoke about can be achieved only if we are able to create a sense of collective consciousness in adhering to those notions and help ameliorate the victims of justice that are being faced. The faith of people in the rule of law and its recognition will depend upon our ability to advance the cause of justice. In this country, we pride ourselves on the strength of the Indian democracy. But as Justice Gogoi observed, we need to recognize that democracy, rule of law, and justice are deeply interconnected, and a threat to any one of these principles will fundamentally affect and will be a direct affront to the vision of justice that we hope to achieve. I am grateful to Justice Gogoi for delivering this thought-provoking lecture as a tribute to an extraordinary individual, Mr. Ramnath Goenka. Mr. Goenka's steadfast passion and commitment and dedication to nation building was reflected in everything he did in his life. Mr. Goenka was a distinguished member of the 5th Lok Sabha during 1971-77, representing Vidisha constituency of Madhya Pradesh. Earlier, he had been a member of the Constituent Assembly and also a member of the Provisional Parliament. Prior to that, he was also a member of the Madras Legislative Council during 1926-30. What an extraordinary journey that he had. Upon his demise in 1991, a tribute was made in the Indian Parliament, and I quote, "In his death, the nation has lost a dynamic personality and a relentless crusader of freedom of the press and the democratic values. His incomparable services to the nation during the freedom struggle and later to journalism will be remembered for a long time to come," unquote. Many of us in this room will know about the inspiring contributions of Mr. Goenka in spearheading the values of independent journalism, and the Indian Express Group itself is a testament to his deeply held values of honesty, integrity, and rectitude. But it needs to be said that Mr. Goenka reflected these values even as a distinguished member of the Constituent Assembly. During a debate relating to taxation on advertisements published in newspapers that took place in the Constituent Assembly on 9 September 1949, Mr. Goenka observed, and I quote, "So far as I am concerned, I am not proud of the fact that this entry finds a place in the central list. In fact, this taxation had been condemned as far as 150 years back in the advanced democracies of the world. There is no constitution in the world where such an entry of taxation of newspapers exists. I am one of those who will say that newspapers are not money-making propositions. I will say that newspapers are there to serve the public and give them a free flow of information. I am one of those who will go the whole hog and say that newspapers should not be allowed to make any considerable sums of money," unquote. He was a daring person far ahead of his time. As I end my concluding remarks, I would like to thank all the dignitaries present here today on this occasion who responded to our invitation and participated in this lecture. Participation of civil society in strengthening the democratic fabric of our nation is the only way by which we can achieve the visions of justice that Justice Gogoi articulated. I would like to take this opportunity to thank the management and leadership of the Indian Express Group, Mr. Ramnath Goenka, the executive director, the chief editor, Mr. Raj Kamal Jha, and resident editor, Ms. Seema Chisti, and all the staff of the Indian Express, and also the faculty members and staff of OP Jindal Global University for making the Ramnath Goenka Memorial Lecture a memorable event. Thank you very much.
Thank you so much for the thank you note, and thank you all of you for being here with us this evening and for being a very warm and receptive audience. And no cell phones rang. Thank you so much. Thank you, sir.